a problem that is called as a problem finding for the aggrieved to get the solution. That problem is not render solution that all principles of previous comes under the null hypothesis. If you are finding a specific problem and finding a specific solution for that, it comes under our hypothesis. To establish our hypothesis as a solution research methodology, we should use a tools of study. This inversion test is comes under the in research methodology, particularly especially in legal research methodology. The inversion test is special test or comes under the tools of study to render strategies precedent. There are four steps in this inversion test. First step is frame carefully the proposed principle. Already one principle is it. Second one is invert a word or phrase which reverses the meaning of the principle. Third one is let us consider the following question. Before passing a precedent or overruling, the judges should ask themselves, international judicial system judges should ask if the court had the new proposition in mind when reaching its decision, whether it is a new proposition or not. Then, and had accepted it as a good law, whether this new decision is considered as a good law or not. This should be comes under mind. That is discussed in detailedly discussed in common sense in law. That disciplinary is very essential ingredient for every judicial officers all over the uh, judicial system. International judicial administrative system should are following this common sense in law. In that third step, fourth step of inversion test, if the answer to the question is yes, then for what? If the court had new proposition in mind. If the answer is yes, the proposition cannot be the correct principle. Previously decided judgment is not correct. So we can render a new judgment, new precedent. Can you understand? Otherwise, also we should follow that new proposition should accepted as a good law. Good law means it should be considered as a social consciously. It should be good one, noble one. If we ask this previous judgment is um, uh, that is if the court had the new proposition in mind, if we are going to find out the problem and a new solution, if the court has had the new proposition in mind when reaching its decision, if the answer is yes, we need new proposition, at that if the answer is yes, likewise that new proposition of judgment overruling of previous judgments and it is considered as a judicial precedent, that strategies will only cause uh, goody to or noble solutions. In that ingredient is asked yes, then the proposition cannot be correct, then the proposition cannot be correct principles, previous citations or judgments can be overruled. This is called as the inversion test. Example, the judge in his judgment stated that the manufacturer owed to duty of care of the consumer, similar to the fact that motorists owe the duty of care to pedestrians. For example, manufacturer of a vehicle manufacturer has a responsibility of safety of that vehicle driver also. Likewise, vehicle driver should have accountability or duty of care of pedestrians at roadways or whatever means. Would the fact that the motorists owed a duty of care to pedestrians be part of the ratio? We apply the inversion test now. In following way, step 1, drivers owe a duty of care to pedestrians. Step 2. Invert. Drivers don't owe a duty of care to pedestrians. Step 3. If the judge had read the proposition in Step 2 as the correct statement, he have nonetheless decided that the manufacturer owes a duty of care to the consumer. Step 4. Clearly the answer is yes, because there is nothing contradictory about saying the motorists don't have the duty of care of the pedestrian, while the manufacturers do owe a duty of care to the consumers. Conclusion. These propositions are not mutually exclusive. The conclusion is that no matter how accurate the proposition may be, it does not necessarily form part of the ratio decidendi. The decision must relate to the facts of the case. The proposition is not governed by all the facts, but by the material facts. International judicial system, before rendering justice with consciousness, common sense, this ingredient is essential. The decision must relate to the facts of the case. The proposition is not governed by all the facts but by the material facts. Then we are going to tool of study of Goodhart test. Professor Goodhart, though American, has spent most of his professional life in England and was professor of jurisprudence at Oxford. He renders this following steps. First step is in Goodhart test, the principle of a case is not found in the reasons given in the opinion. Second one is the principle is not found in the rule of law set forth in the opinion. Third one is the principle is not necessarily found by a consideration of all the ascertainable facts of the case and the judge's decision. Fourth step is the principle of the case is found by taking account of facts treated by the judge as material.